You know, we hire professionals for one big reason: peace of mind, especially when it comes to life's biggest decisions. But what happens when that expert, the person you trust, gets it completely spectacularly wrong? We're about to dive into a landmark legal case that totally changed the answer to one simple question. When a service fails, what are you really owed?
Okay, just imagine for a second. You find your dream house. You do everything by the book, you pay an expert to check it out, and you get the all clear. Then it all falls apart. Literally. Now, beyond the money to fix it, what about the stress, the frustration, the sheer disappointment? That is the heart of what we're talking about today. And trust me, the legal answer is probably not what you think.
So let's set the scene. Our story kicks off with a couple, Mr. and Mrs. Watts, and they were looking for something a lot of us dream about: a beautiful country house, a place to get away for the holidays. They weren't just buying a building, they were looking for a peaceful escape.
And after a long search, they found it, the one. It seemed absolutely perfect. But being smart about it, they did exactly what you're supposed to do. They hired a professional surveyor to inspect the whole place. See, they weren't just buying a house, they were buying that all-important peace of mind.
Now let's be super clear on what a surveyor does. This isn't your buddy who's handy with a hammer. Nope. This is a qualified expert whose entire job is to spot the hidden problems, the kind of expensive, soul-crushing disasters that you really don't want to find out about after you've already signed on the dotted line.
So the surveyor, Mr. Morrow, he does his inspection, writes up his report, and basically gives the house a clean bill of health. The Wattses, feeling reassured, went ahead and bought their dream home. But that feeling of relief? Yeah, it was about to disappear fast.
And listen, this report wasn't vague or wishy-washy. It was a clear, professional opinion. It said the house was sound, that it had no major defects. This was the big green light they were counting on to make the purchase. And it was completely, utterly wrong.
So, what was really hiding inside that house? We're not talking about a few loose floorboards here. This was a catastrophe. Widespread dry rot, a leaky roof, bad plumbing. Part of the ceiling was literally collapsing. Their dream home was actually a total nightmare, and the expert had somehow missed, well, everything.
Well, of course, the Wattses sued the surveyor. I mean, wouldn't you? Part of their lawsuit was pretty straightforward. They wanted the money to fix the massive damage. But they also asked for something else. Something for all the stress, the frustration, and the crushing disappointment of it all.
And this is where we get to the real legal puzzle. Can you actually put a price tag on that kind of emotional damage? Think about it. The whole point of hiring the expert was to avoid this exact kind of stress. So shouldn't he be on the hook for it? That was the big question the court had to answer.
The entire case really boiled down to this one crucial difference. On one side, you've got the financial loss, the actual dollars and cents it costs to fix the physical problems. But on the other side, you've got emotional distress. That's the invisible damage, the anxiety, the frustration of your dream turning into a nightmare. And that's way, way harder to put a number on.
So this case makes its way all the way up to the Court of Appeal. And an incredibly influential judge, Lord Justice Bingham, is the one who has to make the final call. His decision would end up setting a rule that's still used today, and it all came down to drawing a very fine but very important line in the sand.
Okay, here's how the court broke it all down. First, the judge agreed, yes, the whole point of hiring a surveyor is for peace of mind. But then, and this is the game changer, he separated the feeling of disappointment from the actual physical hassle of dealing with a broken-down house. And in that one little distinction, everything changed.
Lord Justice Bingham's ruling was so clear. He said, and I'm paraphrasing here, look, a surveyor's contract isn't a promise of happiness. He explained that you can get money for the physical inconvenience, the stress of living in a construction zone. But you can't get money just for injured feelings or being disappointed that your dream didn't work out.
And just like that, this judgment created what we now call the Watts versus Morrow rule. And even though this all happened back in 1991, its logic is still used all the time in all kinds of cases about professional mistakes, whether it's about a house, a car, you name it.
So what does this all mean in the real world? Well, you can make a claim for the tangible stress and discomfort, like the absolute misery of having to deal with a leaking roof in the middle of winter. But you can't claim for just feeling let down or frustrated that your perfect vision got ruined. The key is the stress has to be tied to a physical problem. So if you only remember one thing from this explainer, make it this. The law draws a very firm line. You can be compensated for the stress caused by the physical mess, but not for the disappointment of the shattered dream itself.
Which leaves us with a pretty big thought, right? The next time you hire an expert for that so-called peace of mind, just remember what you're legally buying. It's a professional shield against physical and financial problems, but it's not a guarantee of happiness. It's a subtle difference, but a powerful one. It really makes you stop and ask, what are you really paying for?